Welcome to This Explainer. Today we're diving into a truly fascinating legal battle. And I mean, it literally has it all. It perfectly captures that profound tension between property rights, religious freedom, and the absolute limits of government power. We're going to look really closely at the Waqf Amendment Act of 2025, and specifically how the Supreme Court of India is navigating the massive constitutional questions it raises. And look, this isn't just some abstract theoretical debate. This legislation is actively being tested in real time, completely reshaping the landscape of property and religious law. So if you've ever wondered how judges actually weigh competing fundamental rights against the state's power to regulate, well, you are definitely in the right place.
Here's our roadmap for today's explainer. We'll start off with the Constitutional Balancing Act, then we'll look directly at the Waqf Amendment 2025. After that, we'll see how the Supreme Court steps in, explore the competing perspectives, and finally ask, where exactly is the line drawn? We're going to take a rigorously unbiased look at all of this.
All right, let's jump right into Section 1, the Constitutional Balancing Act, Rights versus Regulation.
Before we can even really understand the controversy around the 2025 amendment, we have to understand the core tension at the heart of this entire debate. It's all about that super delicate balance between fundamental rights and the regulatory power of the state. And that brings us to a really foundational legal concept, the presumption of constitutionality. Think of this like a massive heavy weight placed securely on the government side of the legal scale. Basically, whenever a legislature passes a law, the courts start with the assumption that the law is completely valid. The court doesn't just sit there and question whether the law was a smart choice or, good policy. Instead, the heavy burden of proof lies entirely on the party challenging the law. They have to prove, without a doubt, a clear violation of a fundamental right, or they have to show that the legislature lacked the competence to pass it in the first place, like, say, a state government trying to pass a law on a subject that only the central government actually has jurisdiction over.
So this framework sets up a very specific constitutional tug-of-war. On one hand, you have Articles 25 and 26 of the Constitution, which fiercely protect individual freedom of conscience and a religious denomination's right to manage its own affairs in matters of religion. The state absolutely cannot dictate theology or internal spiritual practices. But, balancing this out, the Constitution simultaneously permits the state to regulate the secular activities associated with those religious institutions. We're talking about secular administration here, things like managing bank accounts, auditing funds, maintaining physical infrastructure, and just ensuring overall financial accountability. And here's the crucial part. The state can regulate these administrative functions even without the consent of the religious denomination. So the ultimate friction point for the courts is always figuring out exactly where protected religious affairs end and permissible secular administration begins.
Moving right along to Section 2, the Waqf Amendment 2025, a case study.
Now that we kind of understand the rules of the game, let's see how this Constitutional Balancing Act applies directly to a real-world scenario, one that has sparked some really intense debate. The Waqf Amendment Act of 2025 introduced three major on-the-ground changes. First, it significantly altered the recognition of what's known as waqf by user. Historically, a property could be recognized as a waqf simply because it had been used for religious or charitable purposes for a very long period of time, even if there wasn't a formal written deed of dedication. Changing how this is legally recognized basically shakes the foundation of how thousands of properties are classified. Second, the amendment mandated changes to the composition of Waqf Boards and the Central Waqf Council, explicitly requiring the inclusion of non-Muslim members. And third, and this is a big one, it empowered a district collector to determine, through an inquiry, whether a claimed Waqf property is actually just government land. Make no mistake, these are massive administrative and structural shifts.
Unsurprisingly, changes of this magnitude triggered immediate, forceful legal challenges. Petitioners threw this massive constitutional net over the act, invoking practically every major fundamental right you can think of. They cited Article 14's guarantee of equality before the law, Articles 25 and 26 protecting religious management, and Article 300A, which guards against the arbitrary deprivation of property. Their core argument? They said these amendments didn't merely tweak bureaucracy. No, they argued the law fundamentally crossed the line from permissible secular oversight into outright discriminatory religious interference. The challengers essentially claimed that the entire apparatus of the new law was designed to target and dismantle a denomination's ability to autonomously control its historic religious endowments.
So, what happened next? Let's get into Section 3. The Supreme Court steps in. The scalpel approach.
When faced with this massive challenge, how exactly did the Supreme Court act as the referee? Well, often, when a controversial law is passed, petitioners will immediately ask for a blanket stay. Basically, they want the court to just freeze the entire law and pause its implementation while the legal arguments play out over the coming months or even years. It's definitely the easiest route for challengers, but the court, they actually declined to take that route here. They didn't strike the whole thing down or freeze it as a single indivisible unit. Instead, the court chose to use a judicial scalpel. They recognize that while that presumption of constitutionality we talked about demands deep deference to the legislature, it doesn't magically exempt any individual specific clause from being heavily scrutinized against the fundamental rights it might be violating.
When applying this scalpel, the court drew a very, very clear line. For broad administrative changes, like the provisions restructuring the board composition or updating record-keeping requirements, the presumption of constitutionality held firm, at least for now. The court reasoned that at this interim stage, these could be viewed as falling safely on the secular administrative side of the line. But, and this is key, the presumption yielded entirely when it came to other parts of the law. The court decisively stayed specific provisions, most notably the one allowing a unilateral collector-led determination of Waqf status pending rulemaking. The reasoning here is absolutely critical. Authorizing a local executive officer to unilaterally determine the character of a property without adequate procedural safeguards or a rigorous judicial process, well, that appeared to completely bypass the due process requirements of Article 300A. When it comes to fair process and the deprivation of property, the presumption of constitutionality simply had to yield. Which brings us to Section 4, Competing Perspectives, Holding Up the Mirror.
To truly grasp the gravity of this legal battle, we need to ensure we hear both sides with equal weight, focusing purely on the legal arguments. So let's look at the supporters of the act. They argue that regulating the composition, transparency, and financial oversight of statutory bodies that administer vast tracts of property is just a perfectly legitimate secular function of the state. They strongly point out that this is wholly consistent with existing legal precedents, like state laws that currently govern Hindu endowment boards or major temple trusts. To them, this is just standardizing accountability. Opponents, however, counter fiercely. They argue that including non-Muslim members on bodies that might end up adjudicating the religious or customary character of a Waqf crosses a really dangerous line. To them, this isn't just secular administration or balancing a ledger. It is direct, targeted interference with the denomination's theological and institutional autonomy.
Building on that, supporters maintain that painting this amendment as some sort of attack on religious freedom drastically overstates the reach of Article 26. They truly believe the fundamental right to manage core religious affairs remains completely intact, with the state merely updating the administrative scaffolding around it. Opponents, on the flip side, focus heavily on the immense powers given to the district collector. They ask a really critical question. If a single district official can unilaterally strip a property of its long-held status, is that just simple administrative regulation, or is it actually a tool for targeted erasure? They argue that no equivalent unilateral mechanism exists for other religious endowments in the country, and because of that, there's a deep fear that this allows state officials to act arbitrarily against specific institutions without standard judicial oversight.
Let's bring it all together in Section 5. Where is the line?
As we wrap up, the ultimate takeaway from this explainer is a much more nuanced understanding of constitutional law. This Waqf Amendment legal battle proves that the presumption of constitutionality is essentially a doctrine governing the allocation of the burden of proof. It dictates who has to make the compelling argument first. But, and this is the crucial lesson, it is never a shield of total immunity from judicial scrutiny. A statute can absolutely survive the presumption in its entirety as a general framework, even while individual clauses or mechanisms within it completely fail the test and get surgically struck down or stayed by the courts to protect our fundamental rights.
Which leaves us with this final pivotal question. As the Supreme Court moves toward a final adjudication on the merits of the entire law, how will they ultimately rule? Will they view these amendments as permissible, standard, secular regulation of property management, or will they rule it as impermissible interference with a denomination's core religious affairs? The interim orders have really only just begun to sketch out where Indian jurisprudence will draw this defining line. It's a profound constitutional test, and the final ruling is something we should all be eagerly watching. Thanks so much for joining me for this explainer. Until next time, keep questioning where the balance of power truly lies.